Welcome everybody. Here tonight with Jamie and Travis, and maybe Jeff may be joining us shortly. If not, but I just want to get
Hey everybody.
your opinion on everything that's taking place in Steven's case in the last since July.
Uh, so we had first a decision from the Wisconsin Court of Appeals, which was very, very disappointing. And I really thought on one, if not two issues, she had a really good chance of getting the Wisconsin Supreme Court to determine that he was entitled to at least a evidentiary hearing on those two issues. I felt very, very confident about that. And then we got it's not really a decision, we got the order from the Wisconsin Supreme Court saying that, they weren't going to hear the case. The Wisconsin Supreme Court has discretion whether they're going to take cases or not, just like the U.S. Supreme Court. And they said, nope, we're not going to hear it. It was like a one-liner decision, and unfortunately, that was a major punch to the gut. It really took the wind out of the sails of what Steven realistically has in terms of an appeal proceeding forward. It's just terrible. So he really needs a major break at this point. That might come from the Netflix case. Hopefully, I've seen that happen in other cases. A defamation case popped up some information that really helped in the post-conviction process. But essentially what you have is Stevens and Teresa Halbach's blood in the RAV4. And, that's very, very difficult to get over. Zellner did an excellent job in working with what she had, but and I thought raised a few very, very good issues. But when you've got that kind of evidence in the vehicle, you got to come forward with some pretty earth-shattering stuff. What I've always referred to as like smoking gun DNA, like he had in his first case. Or somebody to recant their testimony entirely. That's usually with a identification case, but you need something on top of that. So here he would need somebody, assuming law enforcement did some or all of the things that are floating around, that somebody in law enforcement came out and said, yeah, this is what really happened. And, I really was starting to think about when the first time she put a billboard up, or the benefactor that she's working with, the billboards on the tip lines. I can't remember exactly when that was, but it seems to me it was before her, it was after her initial brief was due. Then she got an extension on that, but it seemed like that reward money came in and the billboards went up. It was well before the decision of the Wisconsin Court of Appeals came out. Do either of you guys remember, Jamie? You remember when the billboards went up?
Wasn't that after December? when the I want to say 4 years ago, maybe it's 5 now. Thought maybe January. I thought.
Of 2018, after the stuff with the bones came up.
Yes, yeah. So that would have that the initial when that was found, I believe, was in December of 2017. So yeah, it would have been probably 2018.
So we were sitting around talking about this case together in whatever format, whatever platform since 2017. Is that when MAM 2 came out? October, November of 2017 or 2018?
2018 it came out.
Pardon?
Yeah. 2018 is when it came out, but the as far as the bones, that discovery of there was a few people that found the bones issue, and that was in December. I want to say it was like December 17th or something of 2017.
No, it's 2018, December 18th. And yeah, you, me, and Richard,
Allie,
Julie, Allie, I had sent something to Richard and said, there's a problem on these bones. And then I said, I want to do a thing, but I want to involve everybody researching it. And then Finn and Julie, I believe, pulled up locations for me. There was a lady from Boston that was around a lot. And then our friend in Missouri contributed to that. But yeah, that was December 18th, 2018. And pretty earth-shattering stuff that they had returned the bones. Even more surprising that Zellner didn't know about it until another supporter / researcher emailed her, and then she filed another motion to remand. But as we all know, that that one was granted and then delayed things. And then finally the brief got filed about a year later. And, we've all gone over the merits of the her brief, her arguments, her issues, the state's response, which was largely procedural, that's really the sad part about all of this, is that because Zellner dismissed, so Stephen had a pro per representing himself appeal a post-conviction motion, 97406 motion on Wisconsin law, motion for post-conviction relief that he's representing himself on. And then, his family and his number one supporter at the time were able to write Kathleen Zellner and get her involved in the case. She came in, substituted in as his attorney, and unfortunately dismissed that appeal. And then the Wisconsin court, first the trial court judge, the circuit court judge, and then the Wisconsin Court of Appeals said, yeah, if you do that, you're procedurally barred. So, we all had that ingrained in our forehead, procedural bar. It's just really tough for a lot of people to take, that.
So one question for you though, Travis, as far as the filing in reference to the bones, and we had talked, and like you said, you're surprised that some of this didn't really get their attention as far as validity or legally. Is it just a matter of their perception that, because everything that we read back then, when we were looking this stuff up as far as the 974.06, it stated right in there, that they legally had to hold these items due to the fact that they were still pertinent in Stephen's appeal case. Is it just a matter, are they basically saying, well, yeah, that's the way the law is written, but yeah, we're just going to negate that and kind of go our own way? That's the way it kind of seems now.
Yeah, I can't recall, Jamie, the exact wording and the opinion about that, but yeah, they just glossed over that. There, as we pointed out, there's no remedy in the statute. It never provided for a remedy if you didn't do it. What the state argued is that um, just because these bones were found in the quarry and that they uh, were human because they returned them to the funeral home to be turned over to the family as Teresa's bones, then, um, they're human, which means, and her, so there was a big materiality argument. And it was kind of like, well, so what? Well, Kathleen's argument was, well, a guilty person wouldn't take the bones off their property, as the state is having people believe, taking it from the burn pit next to the trailer, in between the garage and the trailer, taking those bones um, and putting them out in the quarry. That's what the state would have you believe, and he just did a bad job of it. But Kathleen was arguing, no, the expert at the time of trial said there was another burn site. It was in the quarry. He thought it was the primary burn site, and that the bones were planted. And Kathleen, you remember those arguments that she had. She said, nobody's going to be dumb enough to return the bones and spread them in their own house. At the time of trial, they were arguing, well, these aren't human. These aren't human. And I know Millbilly's gone into depth on that, but so to answer your question, it's they're just not seeing how that's material, and why, in other words, so why is this significant? And part of that goes back to Stephen's blood is in the RAV, Teresa's blood's in the RAV, it's on the property. Get us beyond that. And Kathleen would talk a lot about that. What in these post-conviction proceedings, you're trying to undermine confidence in the verdict. So let's go back to that fundamental. And again, it's her blood, his blood in the vehicle, and all of the things that she came up with. First she started out, she thought she could get this forensically. Remember, she thought she could age the blood with those experts. A couple were from Europe, one was in the US. We never saw any of those official reports. This was when she filed the motion for additional scientific testing, and she wanted some blood from the vial so that she could age test it. I don't recall ever seeing any reports on it. What we do hear or see, from my recollection, is in MAM 2, is Kathleen in a roundtable with a couple of other experts, that issue of dating the blood came up by somebody, and then she just quickly said, yeah, it was too degraded to do that. So she shifted gears remember the motion for scientific testing listed suspect A and suspect B and suspect A. I can't remember which one. One was Redaunt, and then the other suspect B was a law enforcement officer, and then she shifted gears when she got all of her testing done that she could do, and then filed the motion for post-conviction relief. And she had a whole new scenario. The state tried to make a little hay with that, but that happens all the time. You know, you don't. So the post-conviction attorney is going in there brand new and kind of looking at everything. And so first you have to lay out what testing you want to do and why that testing is going to have some sort of impact, relevance to the case. And she said, well, if we can age this stuff and the blood is however old it was collected, you know, over 10 years prior in the other case, right? That if that blood is shown to be more than 10 years older than it should have been, in comparing the blood to what was collected in the vehicle, if both of those were, let's say, 20 years old. If the blood in the RAV was, Stephen's blood in the RAV is 20 years old, the blood in the vial is 20 years old, and that could be aged appropriately, you know, there's a major problem. They've got old blood in that car, and it's clearly planted. Unfortunately,
because technically
that didn't
speaking,
pan out.
his
Sir?
blood should be only be 15 years old if it was tested today.
Right. Okay.
But if it came back as being from the vial, it should be 35 years old.
Okay. Yeah. So at the time she was doing that, let's say that was 2015. So your number, you know, it's going to be 30 years old, and you know what, and 10, but it shouldn't be anything. You know, there was such a huge difference. And when I read so I saw that first motion, and I'm like, man, this is really cool. This is gonna do it. If that blood can be aged. And then unfortunately, you know, then when she filed the motion for post-conviction relief, it's just really difficult. And you could kind of see when I first read the brief what the other side was going to argue, that, well, just because 10 people touch a hood latch and leave 100 times the DNA that, or 100 times less than the DNA that they found, or they touch a key fob 15 times and they find 100 times less than the DNA they claim they found on the key fob. Yeah, that's pretty strong evidence that something could be amiss, but it's just not concrete. And so, in other words, it's not an absolute logical conclusion.
So one thing quickly though, Travis, that I guess I just wanted to state here, as far as, you know, they're saying that the blood is degraded, too old to test. Well, isn't it their responsibility to protect that evidence so that it can be tested at a later date? I mean, because if in 15 years it was degraded enough to where they could not test it, why would we not look forward at cases going on and say, well, whatever the procedures are for storing are bad, and
Well,
you can't trust that.
Yeah.
Well,
making
there's a few cases here in Milwaukee. This happened back in the 90s. They were running out of storage at their evidence facility, so they just started throwing stuff out.
Right. So, well, there you'd have a clear spoliation, and then, you know, you'd have to pursue it under that statute. But Jamie, my impression of when Zellner makes that statement, it was too degraded. It was in the context of the samples, which I think they cut in half, that were pulled from. So in other words, they took Q-tip swabs of those samples, and then they cut a portion of those off to do age dating. I don't think they ever, frankly, I don't think they ever got sent to any of those people to even test. I think later on, she had more information from that DNA expert that she had. They would have sent descriptions over there to say, this is what we've got. This is the amount nanograms. And, but if her experts felt it had been stored improperly, mishandled, she could have brought those arguments up back then. But she didn't do that. She just completely switched gears and came up with a new theory. Or I don't want to say a new theory. It's not like she's pulling stuff out of her hat. She's going where the evidence, she really thought that the forensics were going to answer the case. And she thought she had a new cutting edge technology that was being developed by these folks in Europe that could age blood. She really thought that that could do it. And when it turned out that, I suspect they told her, yeah, we've been able to do this, and but it's got to be this and it's got to be that. And, we'll never know, I suppose, because there's no reports from that I'm aware of. I believe in that motion, she stated in her declaration, the motion for additional scientific testing, that she would, that Stephen would pay for the testing, number one, and number two, would provide copies of all reports to the other side. I suspect that the other side has never attached any of those reports to their motions, either because it was degraded due to mishandling. That's one option, but I don't think that's the case. I think once she had her expert go collect those samples and get portions of those samples by agreement, then they transmitted that information, maybe photographs, but certainly they would have sent the amount, maybe her expert, I can't remember his name, but you all remember him, and he had the paper bag and got in the back of the car with her, and she goes, okay, opens it up, this is what we got, and yada, yada. But he would have been able to put in scientific technical terms what the state of the samples would be. And, more pertinent to your question, so they weren't lost, they weren't thrown out like the case where Millbilly's talking about. That's a clear violation of the preservation statute. But the other problem is that, so there's degraded to where you can't do DNA testing, and no one was saying that, but degraded to where you can't do this cutting edge testing. It's a whole different thing. So I don't think you get to mishandling of evidence, improper storage, that type of thing, because first you have to know how to properly store something for what purpose. And generally you want like blood for DWI, let's say, or DUI, OUI, OWI, whatever you call it in Wisconsin. I'm sure is refrigerated, even though there's a preservative in it, one of two types, purple top tubes or gray top tubes. Um, there's preservative in there that will get you by for some period of time, but all of the protocols and the National Accrediting Agency, ACLEA, say, you got to refrigerate that blood. But frankly, I don't know. Sorry about that. But I don't know what the standards are. Dr. Silkman would have to talk about when you collect blood on a Q-tip, what the proper way to store that is. I don't know.
And I'm sure with Q-tips, you're probably losing some of the material just to being soaked into the fabric. So I kind of get that a little bit.
Yeah. So should we talk now about what Stephen's options are going forward, or
Yes.
you want to talk more about?
Well, one more quick question that I got is at what point in our judicial system, and looking at this case, you've dug into it a lot. When does common sense on the prosecution side ever start to come to the forefront in a case? It seems to me in this one, I know it seems like they were blocking a lot of valid information, but when does that, what would have to happen for full common sense to be used in the court and in a trial? Because there's a lot of stuff here that, yes, it was found, Monday night quarterbacking, that stuff that was found after the fact of the trial, like what we're talking about here with Kathleen. But when that stuff is pretty evident, how does a court not look at that and be like, wow,
Well,
okay.
just think if the audio of them finding the bones 2.5 miles off the property, have to expand the crime scene, was available to them. They didn't look at it. There's
Yeah,
lots of things that have come to light after the fact that weren't available. Well, there could have been better things done in Stephen's first trial. Both of them, his 85 case and the Teresa Halbach.
Yeah, so it's like I've been saying, you need smoking gun DNA, or you need someone to come forward and say, yeah, it was me, I planted it, or you need somebody to come forward and say, credible, with some sort of corroborating evidence that, yeah, it was really me. Because what, from our perspective, yeah, it's, there's all kinds of doubt in this case, and so on and so forth. But in terms of the law, you got to have more than something cracking up the door. So what she tried to do was to do it through cumulative, rather than one piece of smoking gun evidence, a recantation, a confession with corroboration, or smoking gun DNA. She tried to do it through a lot of little things and take the cumulative effect of all of those little things to undermine the confidence of the verdict. And that's very, very difficult to do when you have the convicted person's blood in a car with the victims. It's very, very difficult to overcome that. And it just really not aware of cases where unless you can show a bulletproof alibi, or and that didn't even do him any good in his sexual assault case. But on post conviction, because of the doctrine of finality, they make it very, very difficult on purpose. But they've carved out these exceptions for DNA because DNA has been proven over decades to be extremely solid, scientific, and a way of exonerating innocent people and catching the right person even before DNA was used. Later on, it's corrected and addressed a lot of injustices, no doubt. But he needs a hair somewhere that just like he did in his first case. But there, some courts are going to give more leeway, but since we've been in this law and order mode for a few decades now, Jamie, you're just not going to see where courts start looking at what's in this case and saying, oh boy, I've got some questions here. I really, again, thought that they would have given her an evidentiary hearing on at least a couple of issues, and then she could have brought out these things to show the court more. But I think what you're trying to say is,
what's
instead of
happening
letting her
behind?
try and develop all these problems, they just said, nope, we're not even gonna.
It's because
We're not even gonna let you
this is
talk.
political now. There's so many people involved in this injustice. I mean, look what they did to Brendan. They fought. He was supposed to be released, and they fought it. They're protecting.
And that's one of my things too, is honestly, I would have had a little bit of respect for the court if they would have given her an evidentiary hearing. And then if they came back and said, yeah, it just doesn't cut the mustard for us, at least if they considered it, I'd have a little bit more respect for the court then.
Yeah, I would too. And I think a lot of people, a lot of legal commentators have said that they, were at least entitled to an evidentiary hearing on at least one, probably two issues. And, it's very unfortunate. And what's really unfortunate is that they use this technical means of procedural bar to foreclose claims and deny evidentiary hearing and all the other things, because Stephen had filed on his own this screwed up motion for post-conviction relief, and Kathleen decided for whatever reason to dismiss it and start over. And I mean, I was watching a YouTube presentation when Tracy was talking about the decision had come out and going through it and explaining it very, very clearly and easy to understand terms without all the legal jargon that I typically put in there. And when she got close to the part about procedural bar, she literally broke down in tears. I mean, it's sad. And I think she knew then that the Wisconsin Supreme Court wasn't going to look into any of that. They weren't, it's long established law. You should have never dismissed it. she'd been saying for 4 or 5 years that what she should have done is said, look, I'm new on this case. I want to remand this back to the circuit court. And because Stephen's post-conviction motion was just summarily denied. I mean, he had nothing of merit in there. It went up to the Wisconsin Court of Appeals. It was pending up there. And she substituted in that case, then went forward with a motion for additional scientific testing. Fallon, I think, said, well, what are you going to do with this other case? And then she just dismissed it, whereas she should have just filed a letter saying, I'm filed a motion for additional testing over here. And I know that y'all have here. So I either want you to stay this appeal, this motion, so it can be amended, or remand it back to the circuit court so I can add these other claims. And, but she just dismissed it.
So that that being said, I don't know if you know this or anybody else in Millbilly. Do we know what Kathleen's track record is for exonerations? Exonerations and how many she's lost. I've actually never researched that myself, and the reason I bring that up is we know what is she at, like I think roughly 16 or 17 exonerated that she's done, something like that. We know that she does know what she's doing, and it's not like she's getting defeated here a little bit, but many of these she said take 15 years, etc. That they may run for or more, which I mean with Stephen, we don't know if for one, Alan will be alive then. That would be sad. We already know with Dolores passing. But when she had said that these things take that kind of time, I still, even though things look a little bit grim for his case, I still hold a little bit of faith that she does know what she's doing. It's just going to take a little longer than what everybody had hoped.
Well, I think that's a healthy attitude to have, to maintain some hope. I was trying to think how to analogize it. So let's do baseball. Everybody like baseball? So I would say when she took over the case, the game was in the 6th inning. And then did her testing and came up with the theories, filed her motion for post-conviction relief. They were going to even do some more testing by agreement. When that got summarily denied, when Judge Suck at This issued the order without anybody knowing, boom, it's all denied. It went to the 7th inning, and then eventually she filed and did everything really well. So she's fouling off pitches with those 3 motions to remand. Remember those? And she's fouling off pitches. And then the denial of, then her appeal, which got denied, that put her in the 8th inning. And then the Wisconsin Supreme Court's refusal to hear the case. She's in the 9th inning, 2 outs, nobody on, and she's behind by 5 runs. That's been overcome. Red Sox, back when they had the Bambino curse, they were up 3 runs in the 9th inning against whoever it was, and they just had all of these things go bad, and went good for the other team, and but that's really where it's at. So I think that's a pretty fair analogy, actually, that she had a lot of stuff she could play with, a lot of things she could do, but then once that last remand was granted, and then the circuit court, even though she got the remand granted on that issue of the bones, and then she said, no, I'm not going to give you an evidentiary hearing on that. It's one more out. It's one more towards the end, and the game will, baseball, even though it can go on for hours or days or whatever, it's going to eventually end. And so, but like baseball, there's extra innings. Something could come up in the civil case, or something could come up, but where it sits now, it's the 9th inning with 2 outs, and we're really hoping whoever's going to step up to the plate, which is an analogy for evidence that she can use, or a tip or something, somebody's going to show up.
So another quick question for you then. As far as the case goes right now, like you were talking about, if Kathleen sent certain results back to the prosecution's side, and you don't know if they gave a response to that or not, the testing, the rapid testing and whatnot.
I'm not referring to the rapid testing. That was a motion to remand that she lost.
Sorry, I mixed that up.
The age dating.
Okay. But where I was going with this is, at what point is there, so now, right now, the only other option is to go up to the Supreme Court of the United States, correct?
Well, no, she doesn't really have any federal claims.
Okay.
So her options at this point are file new motion for post-conviction relief on the issues they left open for her, which would be because they denied the remand on it. One would be the rapid testing. The other is the paper courier. How do you say his name, Millbilly?
Sawinski. Thomas Sawinski.
So that's the other one, and everybody's had their comments about, what they think the relative strength or weaknesses of that witness is, but they left her an opening for clearly on the witness that popped up, presumably from the billboards, and potentially the rapid DNA testing, because they denied that remand. I have to go back and look at what the grounds were, but so she might have those two, or she can file a writ of habeas corpus in federal court, like Brendan did. But the problem there, as we all know, is AEDPA, AEDPA, and you all know what that stands for, and that the doctrine of deference And I know her tweet said that they're gonna file new appeals or new motions in state court. And they're gonna
And
go to
if anybody doesn't know what that means, go watch Eric Koze's videos because he goes over it a lot.
so it's yeah, I did one thing with him. I did all of the legislative research on how that thing ended up getting passed and who voted for it, who opposed it. There was a Wisconsin senator who opposed it. Feingold was one of the few senators that opposed it. But it had massive bilateral support. And then Clinton happened to be the president at the time, but if they had huge bipartisan support. It was around the time of McVeigh and the Oklahoma bombing, and stuff like 9/11 and Oklahoma bombing, and big stuff like that tends to get Congress to shift the pendulum back. And sometime a lot of times in hindsight, when you make knee-jerk reactions, you throw the baby out with the bathwater. But no one seems too concerned about that. That was passed in '96, so we're 25-year anniversary of EDPA, and then the Supreme Court interpreted EDPA, even though it's not in the body of the statute, under a case called Brecht versus Abrahamson, said that we're going to give deference, and unless it's just an unreasonable application of clearly established federal law, which in Brendan's case, thought it was crystal clear that they'd misapplied the law on confessions, and that his Fourth Amendment rights were violated because of his I'll just call it mental capacity or communication abilities. That that was a unreasonable search and seizure of him, and obtaining that confession. It was coerced under the law, but you all know what happened in the Seventh Circuit in Bonk. They said, no, it's not clearly established enough yet. And then the Supreme Court refused to hear it. So those are our options. Well, there's another option. So, and I'm not sure if they have this in Wisconsin or not, but in Texas, if an attorney screws up on a criminal appeal, let's say you have 30 days to file the appeal, and for whatever reason you file it on the 40th day, and court comes back and says, or the clerk says, sorry, this is late. What you can do is you can acknowledge ineffective assistance of counsel on yourself. You can say, yeah, I messed up. I'm really sorry. This was what was going on. And typically, if the reasons are laid out enough, and the prosecutor will do what they call confess error, which means that, yeah, we agree this would be ineffective, that for whatever reason, it really did get lost in the mail, or, whatever. But on the issue of dismissing that appeal, I don't know if that's an avenue or not, but so that would require Kathleen Zellner filing a new writ to say, now that the Wisconsin Court of Appeals has ruled and the Wisconsin Supreme Court has refused to hear the case, it's clear that I screwed up by dismissing Stephen's original pro se writ. Therefore, I was ineffective as counsel, and you should allow that to serve to reinstate his original petition for post-conviction relief and allow us to amend that to add all of these claims. I mean, if they have that process in Wisconsin, that's a possibility, but she would have to execute an affidavit saying that she totally screwed up and why she screwed up. And then there's also got to be something, I think at the time that was done, the lady that's now the executive director of the Midwest Innocence Project, WIP, who's been a guest on Mammothon, on Tracy's channel and so forth. She would have to probably execute an affidavit also saying, you know, they never ran this by me, or I suspect if they did, she would execute an affidavit saying, yeah, they ran this by me and I told them, no, don't do that. But they did it anyway, or they never ran it by me. But that's why you have local counsel, that's why they're required to sign everything. But just because they sign it, you know, they don't read everything. I don't know 100% if she was local counsel at that time. But Kathleen's admitted in Illinois and federal court in Illinois. And so if you go to another state to practice, they'll let you do that if you're in good standing in another state, but they require you to have local counsel for that very reason, so that mistakes don't get made. You run it by that local counsel and say, hey, I'm thinking about dismissing this so I can proceed with my thing. Do you see any problem with that? So, you know, I don't know what the background on that is. Has anybody seen Jerry or Dean comment about either the court's decision in the appellate court or the Wisconsin Supreme Court's refusal to hear the case? Have anyone seen any tweets from them?
I have not. I'm not on Twitter anymore.
So those are what the options are. She can file new motions for post-conviction relief, but only on what they left open, which is clearly the witness who allegedly saw Stephen's brother pushing a vehicle, or possibly the motion to remand
Brendan's
denied,
brother.
which
Not Stephen's brother. Brendan's brother pushing the vehicle.
I'm sorry, Stephen's nephew, Brendan's brother, or waiting until there's somebody gets religion, for lack of a better, does a deathbed confession or whatever.
I think it is very possible that may happen someday, but it's not going to be to a point where it'll be beneficial to Stephen's case at all.
Well, and so it's about 1,000,000 to 1. They take Andy's deposition in the Netflix case, and assuming he did something illegal or improper. But even if he did, he's never going to admit to it on the stand or whatnot. But who knows? Maybe they do such a great job of cross-examining him that he breaks down and says, "Yeah, I drove the Rev on the property, just like Kathleen said."
Yeah. And that would only come either, I don't know, probably like you said, a deathbed confession, because isn't it Fassbender that has been sick the past few years? People had thought, maybe someday he'll come out with something.
I I, I don't know, but I know personally. I think if Fallon found out about something, this is total speculation. Personally, I think Fallon would figure out a way how to get that to Kathleen.
Well, he technically doesn't he have to?
Technically, he does, but I'm just saying, you know, um,
If he had some,
technically, I would have thought you would have had to, um, if you have all of this stuff off the computer that establishes um, the supposed time frame that people are in the house doing searches, turns out, not to be correct, and seriously undermines the credibility of your star witness. I would have thought that requires something more than a letter from the lead prosecutor to the defense attorney saying, "Here's the CD. Fortunately for you guys, there's nothing of interest or value on here." Um, and we can argue all day about that, like they did in the briefs. But I would have thought that um, that had been settled a long time ago, but it hadn't. And then I was very optimistic, like everybody was. We went over with Richard that what I call the water ski case, but they the Wisconsin Supreme Court, is conservative as it is, which I'm not saying anything about political ideology, conservative, liberal, Republican, Democrat. They're a very conservative court. They tend not to be very friendly to criminal defendants' rights. But they came up with this cutting edge interpretation of Brady, saying, no, the defendant doesn't have to show that this would have made a difference or that's relevant or material. The state needs to explain why they didn't turn this over. And that was very, very encouraging. I remember doing a thing with Richard on it saying, look, it's kind of apples and oranges, but this is people can draw a lot of optimism from that water ski case about the Wisconsin Supreme Court, when confronted with an issue, is willing to do the right thing.
Yeah, and that's not seen a lot. I know there's a documentary that we all watched. There was, and we discussed that on a couple of different channels, and it was in reference to all the drug cases out in Massachusetts where so many things got it was 150 cases got thrown out, and another 150 were under investigation, and those cases got thrown out. They did something right there, and that's the big thing that really needs to be happening more in our court system, because quite honestly, today's day and age, and not just with this group or this community. You know, we see a lot of things that are, you know, they seem obvious to us that they're misjustices or injustice, however you want to say it. Um, but the court needs to get back to that kind of a system where they do look for the truth, and when stuff like this, or you know, situations like this where there's valid topics that have been brought up that deserve at least a little bit of investigation, that stuff should be done by the court. And it's very few and far between that we see that where they actually put in the time and the effort on the prosecution side to come back and say, you know, hey, we were wrong, you know, that this person's innocent. You see far less of that. There's more prosecutors just looking to get another case win.
Yeah, so those two lab techs in Massachusetts, um, I told Richard about those, and you know, it's that you know, there was a couple of things to take away from that. The prosecutors ultimately did the right thing, Jamie, but
Yes.
not initially.
Nope.
It took some lead pipe carrying lawyers to knock some people upside the head. And you remember that one prosecutor, and they were like, well, there's this box, and I didn't see anything in it. And that judge told that, you know, they sent some brand new prosecutor over there. They're like, you know, get your boss over here now. And they, you know, it took a lot, but then, you know, once the thing imploded, yeah, you know, and it turned political. So political can really help you sometimes, can really hurt you. But the other thing to take from that, I felt, was that you can have people doing really bad shit that doesn't take a conspiracy. You know, just people, for whatever reason, a substance abuse problem, a desire to look good and be an overachiever, and then management saying, "Oh, awesome! You know, we're getting 500 tests out of her a day, and you know, the closest person is less than half of that. But who cares? We're getting double the tests." And you know, a culture. Then the other thing that, and it was just one half of a sentence, and I told Richard, I said, you really need to harp on this. That lab used to be independent. It was a state lab, but it was independent of law enforcement. And then they did this restructuring to save money, and they took that lab and put it under the control of the state police.
Yep.
And so now, you know, which most crime labs in the states are run by, as is the federal FBI lab, are run by law enforcement. Colorado's an exception. It's run through the crime labs are run by the people that do weights and measures, test the gas pumps and put the seals on the scales. Well, they also are an independent agency that run all of the tests. Very few states are that way. But when you have the fox guarding the hen house, and you know, you're part of the team, and somebody feels comfortable writing a note to a lab tech, I've never seen this except in this case, need to get Steven in the car, whatever it said, you know what I'm talking about. And need to put it in the garage, or need to, whatever it was. You guys will know what
Need
it
to
is.
put him in the car or her in the house.
Right. Okay. So, I mean, that is just appalling, that you would put pressure on a tech.
Well,
But
it's all the things that happen behind closed doors that the public will never see. It happens every day in all cases. I think it's wrong. If you're actually after the truth,
To me, like when Travis said, sometimes why good people end up doing bad things, it, it's a self-preservation kind of thing. Even with this, like you're talking about with the statement that was made, put them here, put that, that was self-preservation of their, I don't want to say their government, but it kind of is. I mean, their system, it was self-preservation for Manitowoc County to make sure this all happened.
either of you watched the recent 3-part documentary on HBO about the man that allegedly killed 3 women back in 1962? He was in his early 20s. And he was just recently released on parole after being incarcerated for 59, 60 years. Happened in Illinois. He's got top exoneration attorneys from Illinois on his case. There was no blood in the case, but the lot of hair, and they've sent. They had to fight, but they got an order from so he's out, but he wants to clear his name, and which you can do under Illinois law. They'll let you either to get exoneration and he's on parole, so he's still, for constitutional purposes, he's still under all of those burdens. So he's still considered detained. And so you can bring all of those things under their actual innocence process. But they have sent it to Cellmark. Remember Cellmark?
That one doesn't ring a bell to me.
Or do I have the name wrong? They sent it to the same lab that ran the bullet test for bone fragment, which is in Chicago. Is that Cellmark or something else? Forget it. Forget the Cellmark. They sent it to the same lab that Zellner used for the bullet. They had their Zeiss microscopes, and they're like, man, there's still good evidence in this. Anyway, it's an excellent documentary. The documentary was made by the son of the DA. And so it went on over years. He shot this footage, and it goes up to October of this year. He was just released in October, and they've sent the evidence to Cellmark. Golly, it's going to drive me nuts. Anyway, they sent the hair. They got their order to do independent testing, and they've sent that off to that lab. But I was really kind of bummed out. I felt cheated, used almost. So they said that the results will come back in 2022, early 2022. So, but that stuff could come back. It totally exonerates him. And as Zellner has shown, you can recover a lot of money for being improperly imprisoned. Or it's gonna nail the coffin shut on him. or it may just be inconclusive, unfortunately. But I would highly recommend watching that, because they talk about these exoneration attorneys who are top notch there, talk about, yeah, we need something, and I think the term he used is explosive. We need something explosive. And but they had to wrangle just they tried to get stuff to test in the 90s, and the court refused them. At that time, they said, oh, this stuff's been all intermingled. But they went to this lab, same lab that Zellner used for the bullet, to show the bone fragments if it's fired through pig bone, and compared it to FL that they drove out for them to compare, and the red paint, and so on and so forth. They got an affidavit from them, apparently, because they're on camera saying that no, there's stuff of evidential value here. And I recommend that everybody watch that. It's just 3 episodes, 3 hours, and all of them have aired. So if you have HBO, you can watch all 3, one after another. And then, weirdest thing, I'm watching, and then a friend of mine comes on, and they say, yeah, Bill Jansen used to be an FBI agent, and then ended up in Las Vegas as a judge. He's a friend of mine. Said he reviewed the case. He was brought in to review the case. There was all kinds of problems. Not sure how much it comes up in the documentary, but they did a massive reform of the lab after this case, the Illinois Crime Lab. They lost evidence. They're like, well, where's this lady's rings? And then, it turns out they were in a glove. And then where's the lady's eyeglasses? And it turns out it was in a shirt. But just real shoddy evidence stuff, even by 1962 standards. But he went through and reviewed the case at the time. And but this man, he was in prison for 59, going on 60 years, maintained his innocence the entire time. And he finally was granted parole.
What's the name of that show, Travis?
Well, Jamie, you expect me to remember that?
No, don't expect it, but
I'm looking it up. And, to go back to your question, I remember one time.
I do see a birthday sign there behind you, but there's no amnesia involved at that age, I don't think.
I'm way over 50 by 2 decades, so that wasn't for me. But I'll pass them along to my wife.
We got a couple people that been mentioning you. Scooby is in the chat here, Travis. I don't know if you can see.
Scooby, Abraham Lincoln.
Yeah, we got Linda's in here. We got
Linda.
T1, TTM, Stacy Seabrook. Stacy Seabrook came in here for a little bit.
Oh shoot! I wish I would have known, because then I would have figured out a way to tie in that the civil case. And normally one of you asked me, well, what will they be able to get into in the depositions in the civil case? And I would say, well, since truth is an absolute defense, they can pretty much get into anything in the civil case, the defamation case, about the underlying facts of the murder, because truth's an absolute defense. Stacy wrote a song about that, but I don't have the YouTube chat up. But hello to all of those folks. I sure miss the old days when we were talking about all of this stuff all of the time. As you can see, it's nothing changes. Richard used to bring me on to be the bearer of bad news all the time, and Millbilly's doing it now. But
Following suit, Millbilly.
so Zellner, I remember somebody talking about whatever it is. Let's say it's 20 exonerations. I don't believe she's ever lost one. However, that's kind of a nebulous thing because if you bail on a case, does that mean you lost the case, or you're just busy, or that you look at it and it's just like, again, forensics aren't going to help me. I don't believe so. She had that one big case that was the subject of a documentary where the co-defendant did a recantation, and then they got some sort of piece of corroborating evidence. So she had one non-DNA case that she was able to get reversed. I think that boy's name was Ferguson. Is that right?
Yeah, Ryan Ferguson. That's correct.
So that was a non-DNA case. But again, as my friend Tracy brought out at the time, it's why these evidentiary hearings are so important. Remember, they got the DA on. By that time, he was a judge. And the issue was about this guy coming in to give a witness statement, and they had that whole thing about, do you want to be called judge, or do you want to be called so and so? And then the judge up on the bench says, okay, he'll be referred to as Judge so and so. I mean, that's crazy ass shit. But Zellner got him to stumble on a couple of things that ended up getting the appellate court to reverse that judge's ruling. Is why it's so important to be able to get the evidentiary hearing on. But I don't believe, Jamie, that other than that case, I don't believe any of her other exonerations were accomplished
That way.
without DNA. Now, I may be wrong on that. That when I was looking at that, it was 3-4 years.
Well, and my reference to that, is just looking at her track record. That's not to say that this one will be, the next one or not, but she does have a really good track record. It does take time. That's where, to me, that's where the biggest signs of hope are, is with her track record of being that good at what she does. Is that's the possibility that's left, really.
Well, and then and she'll readily talk about this, that her first one, mainly she did medical malpractice, and that requires a lot of science. I used to do medical malpractice defense. It's very science specific, lots of experts. And then you get familiar with some of that science, and then it carries over to forensics, of course. Because that's what forensics is. It's scientific testimony for purposes of trial testimony. So she her first couple of the first case, is real famous. We all know about that. She took that guy's case. It turned out he was guilty. And then she said, I'll never represent another guy I know is guilty again. but she was able to talk to him and get him to let the victims' families know where their remains were, whatever. And then it didn't work, but he was coming very close to being able to get out of prison. And she had a really bad taste for that. And then she screened the cases much, much better. But after that, the first couple in Chicago, they had something that Richard, which, we started talking about these conviction integrity units, CIUs, which goes back to what you were talking about earlier about reforms and when's a prosecutor going to sit down and talk about, when are they going to talk about this stuff? When are they going to, take a real hard look at it?
Look what happened in the Rittenhouse case. Prosecution
Remind us.
Messed up. Like, they did that boy bad. Yes, he shouldn't have been there, but he was defending himself.
That Rittenhouse.
The problem with that one though is that they were intentionally trying to over politicize Kyle's case, and that's where many people saw right through what they were trying to do. And even the prosecutor, it makes you wonder, did he screw up intentionally? Because it really seemed like he was doing things that any seasoned prosecutor should have known better than to try and pull off in front of a judge, especially one that had been sitting for a while.
So, this just goes back to something that's at a minimum, definitely a problem in the courts, and especially in Stephen's case is, confirmatory bias. And, there's other reasonable people that saw that same trial and said, the trial judge was batshit crazy. It's, and so it's, and I saw his interview with Tucker Carlson. I'm glad he did the interview, brought out a lot of stuff. He didn't go from state to state. His dad lived there, and it was normal for him to be there. But the one thing I did not the one hurdle I couldn't get over is why you bring an assault weapon downtown. Now I know it, his constitutional right. He was there to help protect property. There's another HBO documentary about the riots in LA. And I don't know if you remember the LA riots. I do really, really well. But the Korean businesses were being targeted by a community that had a right to be upset with government, the police, Commissioner Gates, but for whatever reason, they were also targeting Korean businesses. And so there were business owners were on the top of their buildings with assault weapons and guns, and their property was protected. So, but
one of the things about though that I've disagreed with, that some statements that were made in reference to this situation was everybody saying, you cannot lethally defend property against a human life, meaning, the property does not override a life. Well, when you look at the times of the olden days I guess when did this change when you were not allowed to use lethal force to defend property?
In
Because
Texas, you can still to this day at night.
well, but here's what I mean by this, Travis. You look when back
That's
in
around the point I'm trying to make, Jamie. What the fuck is a college kid that goes to school in Arizona? What the fuck is he doing taking his assault weapon down to riots other than looking to pick a fight? He wasn't prosecuted. I mean, I believe he was in fear for his life. It had
Yep.
nothing to do with property by the time it got to that point. He didn't shoot anybody defending property. I think he was shot people because he reasonably believed he was going to suffer great bodily injury or death. I don't have a
Oh.
problem with that.
Oh
but,
no, I agree
you know,
there. But
uh,
actually, when I was watching the court hearing, the prosecutor was trying to trip him up and stating that basically going down you do believe that you cannot use lethal force to defend a property type of thing. They were trying to go along those lines. And yes, he did have a gun to protect property. I mean, that's to keep people away from the property. Really, it's not saying you have to shoot them. It's enough to just keep people away. But yeah,
most statutes say a display of force, like displaying a gun, is not a use of force.
yeah.
And so, yeah, that's true. That's messed up. But I don't necessarily think someone's got to go to prison. But I mean, there's two lenses that are looking at that case,
Yeah.
and
Yep.
I'm with you about 95% on it, but I think where a lot of people can't get is what on earth would prompt. It's just like March 6th. There's a bunch of people looking at that from one angle and a bunch of people looking at it from the other, and we
Yeah.
all bring biases or prejudices or certain lens to things. And but to answer your question, we've been on an hour and a half. 40 years a prisoner is the name of that documentary. I highly recommend it.
Thank you. I'm gonna check it out.
If you have HBO, you'll be able to watch it on HBO on demand, and highly recommend it. And it's the same thing. The son is interviewing his father at 2 or 3 different times. And the prosecutor to his dying day was as proof positive there was that they convicted the right person. But he was convicted largely on confession. And the fact that he worked at a lodge where the 3 ladies were staying. But a lot of it was circumstantial, and they showed the parole hearings. They showed the sisters and grandchildren of one or more of these women, and they showed the son and nieces and sister of the gentleman who'd been in prison for 60 years. I'm going to pull up his name. Not good. Don't even mention his name. And there were definitely 2 different. That's the wrong one. That's from 2020. Ignore 40 years a prisoner. Doesn't someone have that in the chat that just knows right away? 60 years. But they're just two diametrically opposed viewpoints, and we've talked about this before. And back when we were first talking to people, we were talking to them on Google Hangouts, but a few people popped in that were from Wisconsin, or they'd be in the chat on Richard's channel, and they say, yeah, I live an hour from there. I would always ask, well, tell me about what this community is like. What's this Manitowoc like? What's this county like? What's this all about? Because that makes a huge difference, when you're trying a case. What's the county about? What's what are these people like? And I try and get a sense of it. And then I met Tracy really early on, and I said, so what are the percentages there? And I think she said 80% have gone on, don't care, or think, yeah, they, convicted him and just went on with their lives. 80%, just don't care. Then the 10% that really have an opinion on it and followed it, 10 to 15% think, yeah, they got the right guy. And then 5% think, there's a terrible injustice.
I live here. I'm not far from there. I talk about this case every day when I meet new people, and 99% of the time, they don't know who I'm talking about. And when I start to describe the case, their first question to me, I don't know why, is he black? I said, no, he's white.
99% have never heard of the case that you talked to.
Yeah.
Now, what about the 1%?
They think they're on the same, that he needs a new trial.
And the truth is that even though things have slowed down, the community is still growing. It's just at a slower pace now.
Yeah, but the community's got to be significant, and it's got to be in Wisconsin, which is, I understand people wanting to go out to the Avery salvage yard, and I understand about that, but and you guys will remember, when, in terms of planning and organizing some stuff, I was never involved with the rally, but with the mammothons and stuff, there's no secret. I said, if you guys want to do something, you need to go to Madison.
Yeah, that's a good point.
You need to quit wanting to see the salvage yard. You need to get on the front steps of the Capitol in Madison and, scream for the rooftops. But,
that's correct. Honestly, I think the reason that most people do want to go there is to have a better understanding of the layout, of how they state that things happen. That, to me, that's I don't even want to say sensationalized, but for anybody that has done a lot of digging. But you're right, that doesn't do anything.
There's a certain element that, there's this murder mystique, and some people are just going out there because it's the scene of the crime. I think most go out there with good intentions, but that's where it's organized. I understand that it's at the courthouse where the case was filed. It wasn't tried there, but I think it's important for the town to know that people don't forget. But getting back to your original thing, yeah, the community grows, and it's great that it's international and that people tweet Governor Evers on behalf of Brendan, but things
Quite
didn't make a change for the West Memphis Three until big celebrities pumped a bunch of money in that case, and big celebrities showed up on the courthouse steps or the Capitol steps in Little Rock. You know,
yeah.
But you know, with Steven's situation, you know, as I said, ninth inning, 2 outs. So I mean, the game's not over. The fat lady hasn't sang.
Yep. And just like we've spoke about it, it's like it's that close right now, and all we got right now is hope that she pulls this off like she has all her other ones.
We just need her to get her day in court or evidentiary hearing. One of the two.
And Travis, that I don't recall, said the documentary is called Murders at Starved Rock.
Yes. Thank you. Whoever posted that, thank you. That's it.
Well,
I highly recommend it. Does anybody have any questions? And then let's.
I don't think anything has popped up in there. That I've been watching the chat the whole time.
Not really. Thank you for coming on, Travis.
It was a great talk, though.
I'm trying to think, you know. There's just not a lot of positive to talk about when you lose in the Court of Appeals and then the state Supreme Court won't even hear any of the issues. I know, you know, Zellner had that tweet, and you know, we're gonna keep going. We're gonna keep going, but
and
yeah, trial, we hope, is a search for the truth. Doesn't always work out that way. And you're right, Millbilly, because of the rules of evidence, things don't come in front of the jury. Things are excluded. And so it many times doesn't look like a search for the truth. And, you know, there's the community, you know, they've raised a lot of questions, especially you with radio calls and.
Speaking of radio calls, I got a new program that I'm super impressed. I'm back listening to this audio again because it's cleaned it up 1,000 times better. And I'm able to pull things out of the background I couldn't hear before. So look forward to some new videos.
Oh, good. So, I mean, you know, to quote Dean Strang, you know, what you can do as a supporter is be up to speed, talk about it. But at this stage of the game, I think what supporters can do, I've been saying for a long time, you know, if you're eligible to vote, be sure you vote in your local elections, because the DA and the sheriff have a lot of power.
Yeah, but the problem is the same people that are running against the sheriff are still connected with this case. They're just passing the torch down.
Yeah,
I mean, look at about it.
we brought up,
when
we
Herman
missed it. That,
when Herman became sheriff, he was running against Andrew Colborn. So
well, there was another guy that brought up the issue in Brendan's case that ran against who took over as sheriff, Fassbender, or who took over? Wiegert.
yeah,
That
Hagel
first
was, yeah.
election, there was a guy that he made that a campaign issue that you extracted a false confession out of a kid, and he lost by under 50 votes. And Wiegert got in, but I don't care where you live. You know, be sure you vote, because that's the only accountability from many times a rogue runaway DA, a rogue runaway sheriff, especially in smaller towns. We have
Being
the
that you
exact
just brought
same
that up,
thing. We have the exact same thing going on here in Texas. I'm sure it's the same in every state. So number one, vote if you're eligible. Like clockwork, even in the silly nilly-willy off-year local elections that have a 30% turnout, you have to vote in those local elections, because those people have tremendous power. And then with the skill set many have in the community that I've had the great pleasure to meet during these last 4 years or so, find out if there's a local innocence project, and find out what you can do to help, whether it's financial, sweeping the floors, answering the phones. Some are well funded and don't need much help. Others need tremendous amount of help. And every exoneration, every case that does get watching the documentaries, watching Ma'am, I don't know what the final numbers have ended up being on that, but millions and millions and millions of people have watched it. But watching these other documentaries about possible wrongful convictions, so what does that do? If that documentary, Making a Murder, hadn't been made, just like the West Memphis 3 hadn't been made, more so with West Memphis 3, one of those 3 in West Memphis would have been executed by now, and the other 2 would still be in
There's
prison.
been 19.3 million views on Making a Murder.
How many?
19.3 million. Within the first 14 days, it was 2.3 million. And then it jumped to 5.5 after 35.
Now, is that just the U.S. or worldwide?
That's just the U.S.
Okay. Yeah, I heard it was over 30 million. I think Paul Capaldi said over 30 million. I didn't even know they gave you the views. Anyway, but watching these documentaries that you all do on Netflix, what does that do? That tells them there's a market for that. And so they're going to go out and seek these. I mean, it's so rare to get these cases while they're filmed in trial. But, if they know there's a market for people being interested about miscarriages of justice, more and more are going to come to light, right? You're not going to have to rely on a local reporter.
If you looked on your TV guide on your dish or whatever you've got probably, I'll bet you 5 more true crime channels than were out there before. A new one pops up all the time, and a new show pops up all the time.
Well, just court TV in general.
Yep. The ID channel, they do a lot of stuff with, they've got their live body cams, show that they're doing, yeah, there's a bunch of them out there.
All right. Well, I want to thank you both for coming on, and hopefully we'll do this again sometime with some good news.
Yeah, I'm sorry Jeff couldn't make it, but I understand. It's always great talking to both of you. And Jamie, it's nice having a more public follow-up chat about it.
Yeah.
I wish there was more of a silver lining, but I think it's important for people to understand just how dire the situation is. And but there is hope. And maybe it's Casey coming up to bat. I don't know, but it something from the civil case could break in the Netflix case, or the tip line, or you just never ever know. But
I want to know, has KB's investigators ever talked to Brendan?
they would have had to have had permission from
their
his attorneys. There was some sort of communication going on, at least between the lawyers. There's no doubt, because we know about the expert.
Mm-hmm.
They said, "Hey, use this expert, man," and they went off in a different direction, and we've all discussed that in the past. But it would be the exception that you would allow because it was up in the air whether Brendan was going to be called, and they had that expert there just in case Brendan did testify, and then they would put that expert on to explain why he's come up with this false story. How many, you guys would know, how many days before the trial was it finally announced that, no, he is not going to testify against his uncle? It wasn't that long before, right?
Correct. I don't know the exact date, but it was shortly before.
So, yeah. And then the other problem you have is if you do allow your client to talk to the attorneys for a co-defendant, and you expect to put your client on the stand, that wouldn't be attorney-client privileged. They could ask Brendan, "Okay, you met with the attorneys for your uncle. What did you discuss? What did they tell you?" And so it's a very, very risky situation. And so I would suspect not.
That's why I truly believe I don't think the prosecution would have gotten away with half of the stuff that they did if Brennan and Stephen were tried together, because they wouldn't have been able to use some of the lies that they did by separating the cases.
Well, yeah, people have talked about that, but it's been years since I went back and checked. But Brendan would have had an automatic right to sever because his uncle had prior felony convictions, and so you have a constitutional right to sever if your co-defendant has felonies. So you're not convicted by guilt by association. So there are pros and cons to severing the case, to keeping them, and I'm not sure if these were always separate cases and they just decided not to file a motion to consolidate, is what we call it, or if they were together. I think they were always separate, and they just weren't going to consider filing a motion to consolidate. The court probably would have granted a motion to consolidate after it asked Brendan questions on the record saying, you realize you have the right to have a separate trial, but you're foregoing that right. But we call that in the interest of judicial economy. It makes a lot more sense to try cases together, but there's pros and cons. It's one of the things we'll never know the answer to. Here's a bigger one. And I kind of figured this out way back in when I started looking through the documents and whatnot. And I said, you know what? I bet Stephen must have been offered a mistrial if he wanted it, but waived it. This is on the juror being excused. And sure enough, going through the transcripts, you have two options. You can insist on a mistrial and we'll retry the case. Or you can waive that and we'll proceed forward. And then Dean and Jerry told him, look, you have either option, but if you go for a mistrial and they decide to retry the case, you're going to have to be defended by the public defender, because we just can't afford to keep doing this case. It's wiped us out. And I'm sure they went back and forth and talked about it, but I'm sure they gave him a recommendation and said, well, I feel good about it, but you always say, the ultimate decision's up to you. But what would have happened if he said, I want a mistrial, and he got some hotshot public defender, and they would have known because all the evidence was in. Remember, this didn't come up until they excused a juror. And under Wisconsin law, in that situation, you have the absolute right to request a mistrial, and the judge said that, but it could also be waived. And the appellate attorneys for Stephen said, no, you can't waive it. Can't waive it. And the court disagreed and said, no, you can pretty much waive just about anything if you want.
One quick question in reference to that, I believe it's Crockett that asked this.
Crockett, how you doing, Crockett? Good to see you.
He said KZ wouldn't be able to help Brennan because of the conflict of interest, right?
He wouldn't be talking to him. Investigators would be.
Well, so you can't really help someone in the courts. Only the attorney of record can file something, and she could not be an attorney of record because of the conflict. And so I don't know, Jamie, when you and I talked privately, I said that could be a shift in Steve and Laura's strategy. It's not looking very helpful or hopeful that in this appeal that just got denied and refused to be heard, that something is going to pop from that would help Brendan. And so they may start to change their strategy on it.
So that brought up a quick question, and I don't know if this is ever a possibility. That is there any scenario where Stephen and Brendan's lawyers could get those two together at all and discuss things between the two? Or would that all? I know they're separate court cases, but is there any scenario where that could happen?
No, not really.
Okay.
there's just nothing, and it's because they're separate court cases. So in the West Memphis 3, um, many of those defendants, they had their own attorneys post conviction, and they were having hearings by themselves until the very end when they went in for the Alford plea, and then all of them were together. Um, the the state said, "Yeah, we'll accept an Alford plea," and Damian Eccles, who was on death row and starting to suffer health wise, said, "Okay, it's not perfect, but yeah." And then Jesse Miskelly, he's real low functioning compared to the others, probably way lower than Brendan even. And so I suspect he was going to do whatever they were going to do. But Jason Baldwin was adamant. No way, no way. And then they sent in a friend of his to talk to him rather than the lawyers to explain more of what the realities were than the legalities. But Jason was very, very upset about having to take an Alford plea. He did not think it was just. And then in the press conference, he said as much, but he changed his mind because he wanted to save his friend. But none of them ever spoke, ever talked to each other for, over 20 years. And of course, Damian was on death row in Oklahoma, so he was on death row and away, but they were all split up. But what's to be gained from that if they got together?
Yeah, well, and that's something I don't know. I mean, maybe being able to find a missing piece was possibly a thought, that only having them together, did it come out, or some kind of anomaly. That's my only reason for asking. T1 did ask a question though too. Can KZ represent Brendan in a civil suit to follow?
Yeah, technically there could be, but Stevens cases would have to be all over and done with before. But why would he change? Laura and Steve got way more for Brendan than Kathleen has gotten for Steve.
Yeah. Oh, I agree.
They had him. They had him an hour away of being popped. They got a federal magistrate to grant a writ of habeas corpus. That's about 1 in a million. The odds of having that happen are greater than hitting the lottery, or less than hitting the lottery. She's, and I went round and round with Paul about this for a period of time. He's like, well, why aren't, Nyrider and Steve more like Kathleen? Well, everybody's got their own style, and Kathleen's a lot, social media, and that's not my style. It's okay if that's hers and that's her success, but
being that you brought that up,
why switch? I mean, he's got awesome lawyers. I mean, why on earth would you switch to her?
Yeah,
even if you could.
Being that you brought that up though, and I've been out of it for a little while. I'll make this quick and short here. I know we're running long, but Governor Evers did the emergency stop to him being released. Has that been legally? Has that overturn been legally taken care of? Like he can't get back out. That was an emergency rejection by the governor, was it not?
Not
That was
Evers.
Attorney
How
General.
do you say it? Evers or
the-
Evers, Millbilly?
Evers.
No,
But
the
that
Attorney
was
General,
Scott
I
Walker
guess.
was the attorney or the governor at the time when that was all going on. Brad Schimmel was the attorney general. Brad Schimmel's the one that put the stop to him being released, which then prompted to have the embark hearing.
Yeah. So, Jamie, what happened with Brendan is he won in federal court, and then they at the magistrate level, and the either the DA and or the state attorney general appealed that to the Seventh Circuit Court of Appeals. And so the order, it always says, shall release the defendant within 30 days if the state, or 60 days if the state doesn't file an appeal. But they filed an appeal. Then it went up, and the 3-judge panel affirmed it. And then they issued an order saying, shall be released within so many days unless the state files an appeal. Was there an emergency?
There was an emergency stop to him being released. I remember that.
Yeah. So what it must have been is they had 60 days to file. They must have had 30 days to file their brief for an en banc hearing, maybe. And then, but they filed an extension for 60 days to file their brief for an en banc hearing. So it was going to result, if they didn't do anything, in him being released. And so they filed a motion saying, hey, look, we are going to pursue an en banc hearing. He's scheduled to be out within 48 hours. We are going to file a brief. We've gotten an extension. We want the time for him to be released to coincide when our brief's filed. That would have been granted in all 50 states. I mean, there's just nothing to that. The governor had nothing to do with that. But it's political. And most people thought, though, most people thought people don't falsely confess to things that they didn't do. Most people thought that, he must have been guilty because he confessed. But fortunately, because of that documentary and the research and the stuff that you guys do, because of the, the Pritzker Center for Juvenile Justice at Northwestern, it's brought all of this stuff to light. Paul talking to Dr. O'Shea's friend, I can't remember, the false confession expert like Dr. O'Shea, but all of this stuff comes to light, but a lot more. And so people do realize, especially after the confession series on Netflix and Confession Tapes, I think it was called. And then they did a series about integrity crime units. My friend Patricia Cummings was on in Philadelphia. They, people understand, no, this happens a lot more than you think it does. But no, it's
The problem is it's not talked about, and that's why we're here.
So channels like this and Discord and so on and so forth are very, very helpful. But ultimately, it's the lawyers in the trenches who've got to step up to the plate and hit the home run. Um, if testing needs to be done, then yeah, you got to raise money. That was a big thing the West Memphis Three needed, and so Henry Rollins donated six figures, and others, and so they could get the testing that Reardon wanted to get done. And you know, it's important, but um, no, discussing this case and bringing awareness that bad shit happens to innocent people over and over and over and over again, and you got to remain ever vigilant, and you got to go vote in the local elections and keep a good person in, or get rid of a tyrant. As And it's really, really difficult. And you can see in these cases how people line up. The Rittenhouse case, for example, the one down in Georgia with the guy jogging through the housing community by the lake. That was one version. Or he was running, he wasn't out for a run, he was fleeing like he was up to no good. And these things are very, very divisive. They charged that prosecutor for not pursuing the case like as a political favor, because the father of the guy with the shotgun that actually shot and killed the person,
Ahmaud Arbery.
Yeah, thank you for saying his name. I apologize. I should be using his name, but he was the one that actually fired the shots. His father was a former investigator for the DA's office, and so they, it's like they whitewashed this thing and da 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 da, and they brought in these other attorneys, and so they're prosecuting her for some obscure statute, misuse of office. I don't know how they're going to get that on and get past prosecutorial discretion, but maybe they got some smoking gun or something. But there's here's one. The guy that just got killed his wife and unborn baby, dumped him in the bay, and just got his death penalty commuted to life.
Peterson.
And there were not many people when that trial was going on that he had didn't have any friends. And and it turns into a mob mentality. That's why it got moved to Redwood City from where they were. And it's pretty dang rare to get a death penalty in California, but they did. And then there was error in the way they picked the jurors, which was clear. Jurors that said they were against the death penalty, but if the evidence was sufficient, they could impose the death penalty, they excluded. Well, that's unconstitutional. So California had the choice to retry the case on the punishment phase. They just said, no, we have life without parole now. We're cool with that. And but he has maintained his innocence all along too, which is I know people throw that out. Maintained his innocence. A a lot of people have maintained their innocence. Sirhan, and, I mean, just a lot of people have maintained their innocence, and um, it's not a big selling point when it gets to the courts, but um, the film producers seem to latch onto that a lot. But um, it's some of this stuff is just seems, for some people, it's just real clear cut, and um, it's disturbing to know that 99% in Wisconsin don't uh, know about the case. Either that, or it's disturbing that all of Millbilly's acquaintances and contacts live under a rock. One or the other, but it's it's disturbing that they're not aware. But Tracy has told me the same thing. I'm
Well, the people that I do come across that do know about the case, they think he's guilty. And when I try to explain, they don't even want to listen. So,
those are about the numbers that Tracy had. I'm not sure what general area she's in the state. Is it close to you or?
yeah, generally speaking, yeah, we're not far from each
Okay.
other.
Um, but she always said 80%, and none of this is scientific, but 80% don't know, don't care. And then the 20%, it's about 15.5. 15, they're where they should be, and 5% totally got.
Well, I know if you talk to people that are from the community, they believe what the media portrayed. So,
Yeah. So no, we got, you got to maintain hope, and sorry to bring the realities to it, but um, hopefully those billboards will do something. And, and a lot of people, I think, Richard used to talk about this all the time, that a lot of people got into it because of Brendan, and what they did to Brendan is just criminal, but evidently not. And then others, uh, when they dove into the case, started feeling the same about Stephen, or I thought it was about, but there were a few that, remember this, Jamie? A few that said, no, I think Brendan did it, but Stephen's totally innocent. There were a few. It was a very small minority, but
Now there was more people that were vice versa, that Stephen did it, but Brennan had nothing to do with it. That's been, I'd say, I know there was a couple of people that looked into some of the statements because he did admit. They looked at it that way. Hey, he confessed, without. But that's also people that they don't look into any of the specifics, the interrogation. Yeah, there's a few of those people out there. More, but there's more that think Brendan did and Stephen had, or Stephen did and Brendan had nothing to do with it.
yeah, but really the point I was making is I think for a lot of people, they saw what happened with Brendan and his attorney at the time, and Lynn Crazy Head, and then fortunately, got different attorneys, but the judge made some rulings that it just really killed him. And then he got good post-conviction lawyers, and that was just a roller coaster. But then it brought him in to these different communities, and then they picked up with Stephen, and a lot of them got convinced on Stephen, but with the exception of a very few. But I've recommended a lot of different documentaries on Richard's channel over the years, and I always drew parallels. There's all of these things that keep coming up now because it was the son who was the documentarian. Um, you just really don't see a lot of any accusations about prosecutorial misconduct. There's allegations about police misconduct, threatening to kill the defendant's family if he didn't confess, that he'd be charged with the death penalty if he didn't confess. He was charged with the death penalty anyway, I guess because he recanted his confession. But they gave him life without a life, which at that time you're guaranteed eligibility for parole, but he didn't get it for 60 years. But there was this crazy guy that they interviewed in a bar, and clean cut, didn't look, like he was crazy, but he just batshit crazy and talking about. So yeah, it was this other, and he has a site, free, whatever the person's name is, and said, started talking to him. Okay, what's your theory? And well, this guy was part of the CIA, see, and he's part of this operation, blah blah blah. I mean, just pure freaking nonsense. And then they would cut to a family member, and it's like, we have nothing to do with that guy. We have nothing to do with anything. We've tried to talk to him and tell him, you're hurting our brother's uncle's case with this craziness. I think they interviewed a couple of other people that were with that group, but there was a big bust up and split. And they interviewed one lady and said, yeah, it was my dream to be there when he walked out of prison. But that turned out not to be the case. You could draw up whatever parallel to whoever in this case from whatever platform or group. I'll just leave that to whatever. But there's just people latch onto these cases. I always said, for three different reasons. There, we're supporters and are fighting the injustice by doing the various things. And then there's so those I always called the truthers. And then you had the sleuthers, armchair detectives, which is good. And then the third group were just in it for the entertainment value. Which Richard said, yeah, originally that's how I got interested in the case, is I was always a fan of true crime. But then I started digging into this, and man, and I think people all wear the three hats at different times to different extent, and why they've been interested in the case for so long. And there's nothing wrong with wearing any of those hats or being in any of those camps, but I always tried to bring people not back to reality, but back to the criminal case, the appeals, because that was the realistic, real world thing that was going to change things. And the other day when we saw the decision came out, there was lots of discussion in that Discord platform, which is a great platform that they have. And there was just no comments about the decision. And I just said, well, or is there just not the realization, or people in denial they don't want to talk about? I don't know, but
It probably brought some shock. I would think that just because what she brought in our eyes, it looks to us it's valid, and when you look at
Yeah,
you see
I don't mean to say that a lot of these things you've mentioned, Jamie, are valid in terms of she did a fantastic job in undermining the confidence of the verdict, which that's one of the big things you got to show, and yet it it matters for nothing because of this procedural bar, and they chop that off, and then they because of politics, or people throw the C word out a lot, corruption. Um, it's really technically not corruption. We've had cases in Texas where there's been awful corruption down in South Texas where they caught a prosecutor collecting a bunch of money. That was in a recent documentary that popped up, raised its ugly head again. But the FBI came in, and they caught that prosecutor and prosecuted him. He went to prison. But no, I mean, politics are a reality, and it's sad when you have this force, and there's problems in this case, and then he was clearly denied justice in his sexual assault case, and it's like, no, I can't even take 5 minutes to listen to you, or listen to your tape, or look at your photograph, or this or that, um, because if I'm even caught having a cup of coffee with you, if I'm caught giving an interview to you, if I'm caught turning over documents and making it easy for you, um, it's going to affect my political reality. And um, there's a million quotes about when it comes to courage, that there are just a few moments in life, and you get to that crossroad, and very few take the right path. They take the easy one, the one they think is going to preserve their status quo. I think you mentioned earlier, Jamie, preserve their way of life, their comfort zone, and so they just take the easy way versus what these conviction integrity units do, and uh, they take the more difficult path on. Yeah, let's look at what the previous prosecutor team, previous investigation team, previous judicial judge did in this prior case, to see if there's potentially an injustice. There should be one in every state and in every large community. Certainly, any county with more than
Well,
250,000
in,
people should
in
have a.
in the cases you've been involved in, how much does it help when you know the judge?
How much did it help with what?
When you know the judge,
Um,
was it any beneficial at all?
well, yeah, but not for the reason you think. Uh, the reason why it helps to know the judge is, I like to think, is because they know what I say or what I represent about a case, or what I represent about, I've reviewed these stack of documents, and this is what's in them, Judge. That they know that they can trust me. So it helps me considerably, helps any lawyer that has a reputation for ethics, credibility, trustworthiness. Um, it helps a great deal
Okay.
that judge knows what you're telling them is the absolute truth. So it
So to flip
helps.
that, now you're a prosecutor. Same thing.
Um, they have the edge because they're usually assigned by courts. It's usually 3 lawyers in a court. Um, the lead prosecutor for court, whatever, and then middle experience, and then a brand new attorney. And they're in there every day in that court. Um, unless it's a specialized case, like maybe sexual assault, there might be a sexual assault unit, family violence unit, a major crimes unit, um, but or a police case, integrity crime unit, they call it. But yeah, they're in there. They're in there all the time with them. Um, so they have the edge, and so that's why it's really important to have somebody that the judges know and that uh, they find credibility with and whatnot, because the prosecutors do have an edge on that. Every judge is different. Every judge is many of them are former prosecutors. I mean, everything weighs in the state's favor, including jurors are more predisposed to lowering the presumption of innocence, um, actually disregarding that, or lowering the proof beyond a reasonable doubt bar, that they'll, uh, well, we just don't know, but do you want to risk it if it's really him? Um, everything stacks. And this goes back 30, 40 years to the tough on crime. And that's still carrying forth. And you see it in elections all the time. Uh, you know, one side, if they're worried, if they're concerned, their campaign will throw out something about, well, you know, this judge, he's soft on crime. Um, this judge, um, he granted a motion to exclude evidence.
And it's not right, because you should be going on facts and truth, not what the public are going to perceive the way you rule. But
And
yeah,
uh, so yeah, it helps to know the judge, but really I just had a case earlier this week where the grand jury no billed my client, but we worked really, really hard with the investigator and on our own to show that the accuser's story just really didn't add up. And the grand jury no billed, but that was a situation where knowing the prosecutor really well um, paid off, because they were open-minded that everything I gave the investigator, that they would evaluate, they would vet, and if it was the real deal, they would put it in their presentation. So they gave a complete presentation, and they're not even required to. They can say, here's the stuff that points towards guilt. They're not required to show the grand jury anything that's exculpatory, because all the grand jury does is determine probable cause, which is 50-50. But get the right prosecutor in there that's fair and whatnot, and says, yeah, and then let me do it without requiring me to put my client on the stand of the grand jury, where I'm not allowed to go in the grand jury. I'm not allowed to make objections. They're just in there. I said, no, we'll just provide a written statement. They said, okay, we'll get that. And so, yeah, but I mean, there's trial lawyers that are just so damn good. It doesn't matter whether they know the judge or not, because they just have a way with people, and ultimately people decide. Now, those trial lawyers that bounce around different states and whatnot, they always have somebody very experienced that knows the local community, that at a minimum helps them pick a jury. I mean, that's just essential. But there's some great trial lawyers in the country. I mean, it's just amazing to watch them. They're just such good communicators and such good judges of character, and can deal with people. They just have the jury in the palm of their hand, and judge can try and do whatever they want. These are the lawyers that can get what we call jury nullification, which you can't even argue to the jury. Hey, you have the absolute right, no matter what the law says, you can still find them not guilty, and they can't do anything against you. So we analogize to the story of William Penn. I'm not going to go into it now, but just look up William Penn, and it's back in the day in England when the king could put a jury in prison until it came up with the verdict that the king wanted. That's no bullshit. And so we tell the story about William Penn, and just kind of leave it there, letting them know that no one's going to question your decision, how you got there, why you did. And so this is, cases where, yeah, technically the person is guilty of some form of homicide, but and everybody can think of examples, but the realities of the situation, justice would dictate that, yeah, technically they're guilty of that crime, but under the circumstances, it's not doing anybody any good for that person to go to prison. And Jamie, what are you doing?
Just listening and responding on the chat.
Anybody got any questions? We need to get out of here. I got my Generac in.
That's good. You need that for next time you guys run out of power down there. You were pulling it all from Minnesota and North Dakota. Now our bills went up.
They're saying that we should expect another 2 or 3 days this year, not like we had last year over a week, but we should expect another 2-3 day solid freeze, which is, really rare here. So you have high winds where you're at, Jamie?
Absolutely.
Oh yeah.
It was 50-mile-an-hour gusts yesterday.
I heard Wisconsin had some really raging winds.
My way home from work last night, half the streets were out. I got home, the tree outside of my house, big ass limb got blown off of it. It's crazy. Trees down everywhere, garbage cans flying everywhere. It was crazy.
And we've already got
semis
snow
just
too.
pull off the road, or were semis blown over? I saw a couple of photos of blown over semis.
I could see that happening because when I was driving home, I was on the high-rise bridge here in Milwaukee, and I was all over the road. It was
No shit.
It was bad. It was bad.
Oh my God, that would freak me out.
It was
you get
creepy.
used to it. You just watch which way the wind's coming from, and then you stay on the other side of the semis. That way, if it does go over,
I was the only car on the freeway.
that's another bad sign.
It was 3 in the morning, so yeah.
Yeah.
But
No, we're ready for it. I prep for winters every year because living up here, you never know what's gonna get handed to you. Luckily for me, where I'm at, I very rarely have power outages, and if I do, they're pretty short term. But I do have, I don't have my house set up on a home standby, but I know how to rewire my electrical box to be able to do it off of a generator and not send power back down the line to the linemen that are fixing it. So I don't ever panic.
Okay, good. Yeah, I got like we talked about, the
And they're smart to have.
well, I want to
yeah,
thank
as
you
long as
guys.
the natural gas can still make it here, because we still need that. But
Well, thank you, Travis, for coming on, and
thank you for having me. And again, good seeing you guys and everybody in the chat. Couldn't see it. Please forgive me for not saying hey. I don't have it in front of me, but hello to all of you that Jamie called out. It's good seeing you again, in a sense.
all right. Well, maybe
There's
I
some
can
good
get.
people on there. But hey, yeah, great talking to y'all.
Get a
We
hold
got
of
to
Big
do it
Jeff
again.
because I know Big Jeff has a lot of questions he'd like to ask you, so try to get that out. But thanks again for coming on, and I'll see you guys next time.
Take care, everybody.
Later,
All right. Bye-bye.
Bye.
and we're done.